Obviously, he's come with IBC also, and we should all also be extremely proud. And my recommendation is everyone have an IBC, particularly within your office, which is definitely going to contribute quite a bit to your internal revenues. Thank you very much, sir, and thank you very much to the chairman SIRC for actually coming up with this session. Thank you.
Yes, thank you, ma'am, for that hearty welcome.
I want to make a global comparison with respect to the various resolution process across the globe, and I want to share few PAP, IRP successful stories which will be very important for chartered accountants, and I'll be concluding with sharing few of my thoughts on what are the professional opportunities for chartered accountants under the IBC law. As far as the IBC law is concerned, if you have to mention in 2 lines, what is this IBC all about? In case if there is a default by the corporate debtor not able to honor the debts, there is an opportunity for the creditor through the committee of creditors to take over the control of the business to a registered resolution professional. During the course of this process, the corporate debtor will be taking a back seat unless and until we find a resolution, alternate resolution plan, or ultimately if it has to go for an liquidation. Coming to the insolvency law, how did this insolvency law come into the force? This is basically a consolidation of existing laws which was dealing with the insolvency, the bankruptcy and recovery. And also there were different laws to deal with the insolvency and bankruptcy for the individuals, for the non-corporates, the corporates and recoveries. What were the laws prior to this insolvency and bankruptcy law being introduced? This Presidency Towns and Insolvency Act was there, which was applicable to certain cities and towns only. The Provisional Insolvency Act of 1920 was there. Both the laws were more than 100 years old, which was very redundant. We had the Sikh Industrial Company Special Provisions Act of 2003 to deal with the Sikh companies. We had the SARFAESI Act to deal with the secured financial creditors. We had the recovery of debt from the banks of financial institution, which is called as RBPD. So these were the various laws with respect to dealing with insolvency and bankruptcy. They wanted to consolidate all the laws. During the course of introduction of the IBC law, 3 of the acts were repealed and 10 of the acts were amended. One of the significant amendment happened was to the company law. The liquidation and the binding process was actually part of the company law. With the introduction of IBC, the entire liquidation and binding process dealt under the IBC laws. No more it is there in the company law. Since it was a consolidation, repealing and make amendment to the 11 laws, it became an IBC code. That's why it was not called as a law. As very rightly when Mr. Rajendra Kumar mentioned, the Prime Minister of the country, Mr. Narendra Modi, then Finance Minister Arun Jaitley also in the House of the Parliament, they acclaimed that the IBC law was the second biggest economic reform in the country only after the GST. The earlier IBC laws, the focus was more on the recovery. But the current IBC law is more on the revival. That is the difference between the pre and the post IBC laws. As very rightly said in the earlier speaker, there are a lot of challenges with respect to any business you do. Always there tend to be some business failures. When there is a failure in the business in spite of a genuine intention, if a business fails, there is an opportunity for you to come under the resolution process. But there is a situation where there are certain promoters who became rich, but they made the companies poor. Those kind of the promoters will not get any relief under the IBC laws. In case of any genuine business losses due to a bad business decision, there are opportunities under the IBC laws to be revived. The primary object of the IBC was to promote the entrepreneurship, to make the availability of the credit, take care of the interest of all the stakeholders, maximize the value of the assets in a time-bound manner. So whatever the process you adopt in the IBC law, there is a very clear timeline compared to our earlier laws where it used to take number of years and there was no certainty with respect to the recovery of the money by the creditors. One more primary object of the IBC law, prior to the introduction of IBC law, we had a very inadequate legal framework. The machinery was not very adequate to have a robust mechanism for the purpose of recovery. Considering all these aspects, the IBC law was introduced. And the IBC has a very defined process. As I told you, one is CRP process, which is for the corporate insolvency resolution process. Then we have a fast track process which is applicable for the small companies. Then we have this PPIRP and also the liquidation is part of the IBC laws. Current IBC laws deals with handling the individuals, partnership firms, corporate entities. So all of them are covered under the IBC laws. As I am talking to you as of today, central government has not notified the insolvency provisions which is there in the IBC law, which is applicable to individuals and partnership firms. As of today, is notified only for the corporates, corporate entities are only eligible for the insolvency process. Coming to the regulatory, IBC laws are regulated by the IBPA board. We have insolvency professional agencies. Institute of Chartered Accountants of India is also one of the insolvency professional agency. We have the adjudicating authorities, the NCLT and NCLAT. And anybody wants to challenge the order of the NCLAT, the next jurisdiction is only the Supreme Court. As per the law of the country, the Supreme Court will have the final say. As far as the stakeholders is concerned, I want you to understand the stakeholders will be the creditors. Creditors can be the financial creditors, unsecured creditors, operational creditors, government dues, workmen dues, employee dues. All of them come under the creditors. And one more significant aspect of this insolvency law is there will be a moratorium when you get into the process of a CRP. What is this moratorium? When a company is under financial stress, when you undergo a insolvency process, no cases can be filed against the corporate debtor. You cannot make any recovery process in the court of law. Maximum you can make the claim to the insolvency professional. And also in case if you are not able to get the alternate resolution alternate resolution plan, and if the company gets into the liquidation, there is a waterfall mechanism which is very clearly defined. Whatever the money collected at the liquidation has to be distributed according to the waterfall mechanism. Coming to the resolution plan, you get a very clean entity because the orders of the NCLT will be binding on all the stakeholders. And also there is a value maximization and there is a certainty with respect to the creditors whether they are getting any money or not getting any money. If they are getting, they will get it in how many days. This is with respect to this IBC laws. I wanted to share few of the statistics. What is the amount of recoveries was made by the IBC compared to the other recovery channels? If you see the figures for the year 2021-22, IBC law alone have recovered about 23.8%, whereas all the recovery channels put together like Lok Adalat, Debt Recovery Tribunal are under SARFAESI, the total recovery is only 14.7%. There is a total disproportionate to the number of cases being handled by the IBC, but the recovery is very high. All the channels put together, the numbers are huge, but the recovery is very poor. This speaks about the success story of the IBC. For the financial year 2023, as per publication of the Reserve Bank of India, the recovery has been 32%. The figure from the other channels is still awaited because that is generally published in the month of December. So we get to know, but RBI has already indicated whatever the recovery is made under the IBC laws are much more than what is recovered under the other laws. Coming to the IBC infrastructure, I wanted to take you through no law can be successful without having an adequate infrastructure. They have set up, we have 50 members, 25 benches and 15 cities across the country. NCLT benches we are having. There are 4,000 registered professionals who are registered with the IBPI. Out of the 4,000 registered professionals, 2,700 are registered with the Institute of Chartered Accountants of India. Out of this 2,700, which is 63% of them registered with ICAI, 90% of them are chartered accountants. One more key indicator you can get is there are 150 registered IPs with the IBPI, whereas only there are 30 IPs with the Institute of Chartered Accountants of India, which means to say most of the chartered accountants who are qualified as insolvency professionals are not in the active practice. That is the conclusion, because the number of IP entities, if you take it, is very less. When you take the numbers of chartered accountants qualified or more to that. And there are more than 5,000 registered valuers, and there are a lot of disclosure requirement with respect to the IBC law to make it transparent and also to ensure that there is independence with the registered professional, there is the insolvency professional. Coming to the MSMEs, this is only an indicator what has been the MSMEs contribution to the economic growth. As per the last statistics, 30% of the GDP is coming from the MSMEs. They are targeting to reach about 50%. More than 100 million jobs are being provided by the MSMEs. Coming to the most important of the government initiatives for the MSMEs, they have worked on a revival framework for the stress for MSMEs, which is the PPRP, which I am going to deal with this. The government decided that they wanted to come up with a special scheme for the MSMEs. That is how this PPIRP was introduced. I am trying to discuss what is this PPIRP and why is this PPIRP and when is this PPIRP introduced. Coming to what is this PPIRP, as I told you, it's a pre-packaged insolvency resolution plan. There is no statutory definition to this in the insolvency law. It essentially refers to a restructuring plan which is actually pre-arranged, informally discussed between the corporate debtor and the creditors to find a solution to the financial stress. I want to give a small example with respect to this PPIRP, how it works. Take an example that the total amount of liability outstanding by MSME corporate debtor is 100 crores. The value of the assets of this corporate entity is 60 lakhs. This is the book value 60 lakhs. You are having a liability of 60 lakhs and 100 lakhs. Let me keep example of 100 lakhs. The book value may be 60 lakhs, but the fair value of this asset is 40 lakhs. Liquidation value is 20 lakhs. So you have a scenario where 100 lakhs is outstanding to the banker, 60 lakhs worth of book assets you are having, but the fair value is 40 lakhs and the liquidation value is 20 lakhs. You want to make a settlement with the creditor. Before entering to the PPIRP, there is an option for you to enter into an informal discussion with the creditors. So the financial creditor, who is a bank or institution, could be a private lender, is fully aware that whatever 100 lakhs outstanding to him, including interest and penalties, whatever outstanding, in case the company goes into liquidation, he can recover only 20 lakhs. But there is a possibility if somebody can come in and give an alternate plan by taking as a going concern, there is a possibility to achieve up to 40 lakhs. The corporate debtor comes in the informal discussion telling that he wants to settle the matter for 25 lakhs. As a financial creditor, even if I am a secured financial creditor and security is only the asset, it makes sense for me to accept this 25 lakhs. Because if it goes to liquidation, I might get only 20 lakhs, option number one. Second thing, if I don't take a decision immediately, if there is a delay in the liquidation process, that 20 lakhs can become 15 lakhs also. Second option is, he has to put some efforts to see that if he can get an alternate resolution plan which can give more than 20 lakhs. How to determine what is the best under the circumstances in the interest of the shareholder? That is how this pre-packaged insolvency resolution plan has been introduced. There is a defined, transparent process to ensure that you get the best value for all the stakeholders. You have to go through a process. When I explain the PPRP process, you will appreciate how transparent and how sound this process is to make sure the interest of the stakeholders are not compromised. Coming to why. This PPRP was introduced because of the pandemic COVID negative implications on the businesses and more so with respect to the MSMEs. During the COVID, you know that huge losses were suffered by the MSMEs. There was a negative impact. There was a negative growth. Based on that, the government decided that they want to come up with a special scheme of PPRP exclusively for the MSMEs. That's how that MSME was introduced. Coming to when, the entire PPRP process came into the force with effective from 4th of April 2021. As I told you, this PPRP is a very small component of the entire IBC laws. There were about 16 sections introduced in the IBC law, 54A to 54P. 51 regulations were there. And they came up with the rules which had only 4 rules in that. It's a very small booklet as far as PPRP is concerned. If you are able to understand the provisions of the sections, the rules and regulations, you will be able to handle and assist the MSMEs in undergoing the PPIRP. This is the classification with respect to MSMEs. With effect from July 2020, there is no differentiation between the manufacturing sector and the service sector. Prior to that, there was some differentiation. Now they have come up with certain values. Having investment and turnover together, you will be falling either a micro, small or medium enterprise. Once you fall into this category, you can take the benefit under MSME. Now, what are the objectives and features of PPIRP? As I told you, MSME enjoys a special benefit of going through a separate legal process, which is an alternative route compared to the CIRP, which is on a faster mode compared to the CRP. CRP as of today takes much more than time. There is an option for you to get a solution in 120 days. And this PPRP is a debtor in possession model. Even if you go under a PPRP, there is no threat for you with respect to the management. Management will continue to be with the suspended board of directors. Sorry, not a suspended. In case of CRP, there will be a suspended board of directors. In this case, they continue to be the directors. The manager will be best with them. But however, with control and supervision of the committee of creditors. And it is more of a quasi-formal. The PPRP is more of a hybrid option, where you are informally discussing with the creditors and also undergoing a normal judicial process. And one more benefit for MSMEs if you are going under PPRP is you have an option of giving a base resolution plan. As I told you in the example, the corporate debtor themselves can give a base resolution plan telling the banker they wanted to pay 20 lakh rupees against the due of the 100 lakhs. So the corporate debtor has an opportunity of giving a base resolution plan. So he will be under the control of the business, of course with the supervision of the COC and the resolution professional. Also, this is an opportunity for MSMEs to enter into a discussion with the creditors before moving on to the PPRP process. You would have already discussed the key commercial aspects with respect to the settlement with the creditor at the pre-admission stage itself. So these are the main features of the PPIRP. Now, what are the eligibility requirements for somebody to get into PPIRP? Firstly, you need to be a corporate entity and you need to be an MSME and there should be a financial stress on them. Also, for you to go under PPIRP, you need to fulfill all these eligibility criteria. One is that you should not be under the CRP. If the company is already under the CRP, you will not be entitled to go into the benefit of PPIRP. You should have not undergone a PPIRP in the last 3 years. Neither you should not undergone a CRP in the last 3 years. You should have defaulted a payment of 10 lakhs and you should be eligible to submit a plan. There are certain ineligibilities for the person to be an applicant, resolution applicant. You need to be eligible under that and no liquidation order should have been passed. If you satisfy these conditions, you will be eligible to get into the PPRP process. What is the process with respect to the pre-admission stage? This is quite interesting. This is the process what you need to adopt if you are an MSME and if you want to get into a PPRP process. First and foremost, you need to pass a board resolution with the majority of the directors approving it. Then you need to pass a special resolution approving that you want to get into a PPRP process. 10% of the financial creditor have to propose the name of the insolvency professional who will be monitoring the pre-admission process. When I say the financial creditors, they should be unrelated financial creditors. Then 66% of the financial unrelated creditors have to approve the name of the insolvency professional. You will be an insolvency professional in the pre-admission stage. Once the application is admitted, you become the resolution professional. Then you have to submit the base resolution plan. You have to make sure that base resolution is compliant. You need to make a provision to take care that you are going to make payment to the operational creditors in 100%. That's one of the requirement. And the directors have to file the form 1 before the adjudicating authority. They have to file a declaration along with the form. First is that they need to clearly mention that this is not for defrauding of any person. They have to give an undertaking that after the application is admitted within 90 days they will submit a base resolution plan or an alternate plan. They have to propose the name of an IP who will become an RP after the application is admitted. And one significant undertaking they have to give is the corporate debtors have not entered into any avoidance transaction. This avoidance transaction, we call it as pure transaction. You shouldn't have entered into any preferential transaction, undervalued transaction, fraudulent transaction or extortionate transaction. Basically, this is what I was telling you. If the corporate debtors, the directors are honest, this pure transaction is something which would be done with a fraudulent intention, basically to give a benefit to certain category of creditors. Because of the PPIRP, they want to ensure that none of the stakeholders are going to lose out on the value what they would have get in case if it had gone for a liquidation. Along with the filing of the application form 1 before the NCLT authorities, RP also had to need to file a report certifying that this MSME has met all the eligibility criteria. The base resolution plan what was given is compliant. And RP has to give a consent form that in case if it goes for PPRP, he will be acting as a resolution professional. So there can be a different scenario when you file an application with the PPIRP. The PPRP application can be filed only by the corporate debtor. In case of a corporate insolvency resolution, a creditor can be filing an application before the adjudicating authorities. What happens that after you file a PPIRP, if a CRP application is filed by the secured creditor or an unsecured creditor, the adjudicating authority has to hear the PPRP application first, only then they can hear the CRP application. Or second option is a CRP application might have been filed, but you have to file a PPIRP application within 14 days. If you don't file the application within 14 days after a CRP application is moved, then adjudicating authority will dispose of the CRP application and your PRP application will not be heard. But you need to appreciate that certain benefit has been given to the MSMEs for filing a PPRP application. In spite of the fact if the application under CRP is filed, still you are given 14 days time to file your PPRP application. Once you file a PPRP application within 14 days, as I said, they have to dispose of the PPRP application before hearing the CRP application. This is the process. What is the process to be adopted with respect to the post-admission of the application? Once the application is admitted, that will be the commencement date for the PPIRP. On the day 2, the resolution professional have to make a public announcement stating that this particular corporate debtor who is an MSME is undergoing a PPIRP, and the corporate debtor has to submit the claims, give the list of claims to the resolution professional, and also they have to submit the base resolution plan. On the day 3, the resolution professional has to appoint a valuer. They will be appointing 2 valuers to give the fair value and also to give the liquidation value of the corporate debtor. Then by day 7, the resolution professional has to constitute the committee of creditors. And when I say the committee of creditors, as I told you, they have to be unrelated financial creditors. In case there are no financial creditors at all of this MSME, they have to form a committee of creditors taking the top 10 operational creditors, and if any claims made by the workman or employee, they also will form of the committee of creditors. After the committee of creditors is formed, he has to convene a meeting within 14 days, calling for the first COC meeting. On the 14th day, after you call the first COC meeting, you have to submit the information memorandum to the committee of creditors for purpose of taking a decision, and also will be placing the base resolution plan before this committee of creditors. In case when the base resolution plan is already accepted by the committee of creditors, there is no need of calling an alternate resolution plan. In case if they don't accept the base resolution plan, the resolution professional have to call for an alternate resolution plan within 21 days. The resolution professional, within 30 days, he has to form an opinion whether any avoidance transaction has taken place. If he is of the opinion that the avoidance transaction has taken place, within 45 days he has to determine what is the value of this avoidance transaction. And within 60 days he has to file it before the adjudicating authorities for the purpose of filing of the application, determining the value whatever with respect to the PUF transaction. An application will be filed to make sure this particular transaction can be reversed or how to recover the PUF transaction amount from the corporate debtor. After this, within 90 days, the resolution professional has to file either the base resolution plan or the alternate resolution plan to the adjudicating authorities, and 30 days from there, within 120 days, adjudicating authority will be either accept or reject the PPRP application or the alternate resolution plan what has been submitted. This is how the base resolution plan is approved. The corporate debtor has to submit the base resolution plan to the resolution professional. The resolution professional is going to evaluate the base resolution plan whether he has made provision for 100% for the operational creditors. When a corporate debtor gives a base resolution plan, if he does not make a provision for the full operational creditors, there is no question of approving the base resolution plan. Even if they approve the base resolution plan, they might have to go and get an alternate resolution plan. So the COC may accept or reject the base resolution plan. In case the COC rejects the base resolution plan, the RP shall invite for a best alternate resolution plan, where they are calling it an alternate plan. In case the COC approves the base resolution plan, that will be filed before the adjudicating authorities for the purpose of approval. In case the base resolution plan is rejected, or if the base resolution plan is not compliant, then the resolution professional is going to publish and get an alternate resolution plan. The committee of creditors are going to evaluate whether the base resolution plan is good or whether the alternate resolution plan is better for them. After evaluating, the COC will take a decision whether to accept, whether to approve or reject the particular plan. There is a situation where the COC may accept one of the plans, either the base resolution plan or the base alternate plan. If they accept it, they make an application to the adjudicating authorities for the purpose of disposing of the application and accept the PPIRP. In case the COC rejects the base resolution plan, then the PPIRP stands terminated. Also, there is a draconian law in case of this liquidation. There is one slight possibility where the adjudicating authority may order for liquidation. Only under one circumstance the adjudicating authority can go to the extent of ordering a liquidation. That is when the base resolution plan is submitted. In case if you don't make the provision for the operational creditors, and if subsequently you get an alternate resolution plan during the course of the PPRP process, in case the corporate debtor has managed the affairs of a business in a fraudulent manner, if he is not taking care of the assets of the business, the COC has a right to file an application with the adjudicating authority to vest the management of the business with the resolution process during the PPIRP itself. In case if such application is filed before the adjudicating authority, if the management is vested with the resolution professional, subsequently whenever a resolution plan is submitted, whether it is an alternate resolution plan or the base resolution plan, if there is no change in the management, under that circumstances they can order for a liquidation. Now, with respect to the base resolution plan, one or two important significant aspects are there. The law tells that whenever a corporate debtor gives a base resolution plan, and when you find an alternate resolution plan, that alternate resolution plan has to be significantly better than the base resolution plan. What is that significant is something which the resolution professional, when he invite for the resolution plans, he has to determine what is that value he has to give it to make it significantly better than the existing plan. The example what I have picked up is, I have given a significantly better plan to be the base point of 8. In case if there is a PRP plan which is at 108, if there is an alternate resolution plan who want to improvise the base resolution plan what is given, he has to significantly improve it by going to 116 only. Then the corporate debtor has an option to improvise it by another 8 points coming to 124. This is the value of significant. And as far as the process is concerned, it will be open for only 48 years. 48 hours. This will open only for 48 hours. Between the alternate resolution plan and the base resolution plan to come up with the best plan. Within 48 hours you need to conclude. If the base resolution plan is best, I think the committee of creditors will approve that. If the base resolution plan is not good, if they feel the alternate resolution plan is better, probably they will approve the alternate resolution plan and it will be submitted before the appropriate authorities. This is a comparison between the PPIRP and the CIRP. In case of a PPIRP, as I told you, it is going to be initiated by the corporate debtors only. But in case of a CIRP, corporate debtor himself can initiate the process. Apart from the corporate debtor, either the financial creditor or the operational creditors also have the option of going for a CIRP process. And the default amount, in case of PPRP, it's only 10 lakhs. In case if it's under CIRP, the default amount is about 1 crore. And also with respect to the conflicts, there will be a less conflicts in case of PPRP because you would have negotiated with your creditor at a pre-admission stage, you would have discussed on the commercials, so the chances of litigation is very less under PPRP compared to the CIRP. The another significant advantage for MSME who is going under PPRP is that they have the control of the business at all times. Unlike in CIRP, on the day one, the entire business will be meshed with the resolution professional. So that risk is not there under PPIRP. Comparing to the timelines, as of today, the PPRP are going to complete it in 120 days, whereas in case of CIRP, it can go up to 330 days. Though the law has not provided for 330 days, various judgment what has come in the recent past, it indicates that the CRP process can go to a maximum extent of 330 days. As far as PPRP is concerned, it is entitled only for the MSMEs, whereas in case of CRP, any corporate person can go under the CRP process. So these are the major benefits for MSMEs to take advantage of the PPIRP. Coming to the proposed amendments, this is only an amendment. This has not been implemented as of today. They have already circulated, the Ministry of Corporate Affairs has circulated, I think on 18th of January 2023. What are the amendments they are trying to bring in? In my opinion, this will be a very good initiative. If these amendments are brought in, there can be more number of MSMEs who will be taking advantage going under the PPRP process. The first amendment they are trying to bring in, currently the PPRP process is eligible only for MSMEs. They want to make it entitled to non-MSMEs also. That is one aspect what they are trying to bring in. Second thing, with respect to the approval of the committee of creditors or the financial creditors, it was 66%. They want to reduce it to 51%. This is the second proposal what they are trying to bring in. And the third thing is with respect to this avoidance transaction. In case of a PPIRP, as I told you, directors have to file that no PUF transactions have taken place. But they want to do away with this. The reason for this is the directors might have entered into certain transaction. They may not be sure whether it falls under the PUF transaction. To give that benefit, they want to do away with it, filing a declaration with respect to this avoidance transaction. And the last amendment, what they are trying to bring in, during the course of the PPIRP, there should not be a threat for MSME CD that the management may vest with the RP. In a maximum case, they want to terminate the PPIRP. Second thing is, with respect to the threat of liquidation, they want to ensure that somebody is going to a PPIRP, there should not be any threat. In the worst circumstances, the PPIRP has to be terminated. These are the few success stories of PPIRP, what has happened in the recent past. Out of these 4 cases, what has happened with respect to GCL, Sri Rajasthan and Sudal Industries and Mruthyunjaya. In first case, the recovery was 100%, 37% in case of this Sri Rajasthan, 30% in case of Sudal, and Mruthyunjaya was 19%. Look at the time duration, what has taken. Only in the first case, it has taken 721 days. That was basically because of the pandemic. During that time, the court themselves have exempted that and given an additional time. Otherwise, they have done in 125 days, 112 and 156 days. But this is more interesting to know the figures of what has happened. In case of Sudal Industries, this was an MSME. They had borrowed 96 crores from Canara Bank. They had borrowed unsecured financial creditors was 26 lakhs. Operational creditor was 5.73 lakhs. 5.73 crores. So the total claim amount was 128 crores. The resolution amount was 37.97 crores. The total realization was 29.51%. The book value of the asset was 61.49 crores. I want to draw your attention to the liquidation value and the fair value. If you see what was the liquidation value of the Sudal Industries was 29.45 crores. The fair value was 52.41 crores. So the realization was 29%, which is coming to 37.51 crores. That is something between the fair value and the liquidation value. So this was a success story where they had a claim of 128 crores. They are able to settle it for 37.97 crores. A new chapter has started, no financial stress. So this was one of the major beneficiaries with respect to the PPIRP process. So another company was Sri Rajasthan Syntex. In this case, the total claim amount was 111 crores. State Bank of India had funded 43 crores, IDB had 33 crores, Bank of Baroda 23 crores, and operational creditors was about 11 crores. The resolution amount, I don't have the information with respect to the liquidation value and the fair value in this case. I am sure that should be anywhere between 40 to 50 crores. That's how the realization amount is 41.71 crores. The realization is 37.35 crores. So another success story where the MSME was under a severe financial stress against an outstanding amount of 111 crores. They paid 41 crores and started a new chapter with a zero liability. This is with respect to the global comparison with respect to PPIRP. How is India compared to UK and US? As far as this successful RA is concerned, in UK and US you can see there is no competitive bidding. It's only the base resolution plan what has to be discussed, negotiated and accepted. And with respect to the timelines, in India we have 120 days. UK and US, both of them are not having any specific timelines. Otherwise, in case of related party plan also, UK and US are allowing for the related party plans, whereas in India there is a restriction under 29A, of course some small exemption with respect to MSMEs. This is coming to the professional opportunities. In my opinion, what are the professional opportunities? One is that in case you are registered valuer under the IBPI, under the PPIRP or CRP, there is an opportunity for us. And if you are a certified forensic auditor, you can do a forensic audit, which is primary requirement with respect to the insolvency process. There are various other professional opportunities for chartered accountants during the CRP process or the PPRP process, right from starting a preliminary stage, as I told you. In case of an PPIRP itself, pre-admission preparation itself, 90 days time is there for you, where you have to prepare a base resolution plan, where you can come up with certain strategies, where you can come up with the restructuring of debts. You can be an advisor to the alternate resolution applicant. You can be an advisor to the committee of creditors. You can be an advisor to the corporate debtor himself. So those are many opportunities for chartered accountants, whether under CRP or PPIRP. Coming to the key discussion points with respect to the reason why the PPRP has not been very successful compared to what it should have been. Actually, there are totally 22 million MSMEs in India today. The number of applications filed is 7 only in the entire country. Only 7 applications were filed. Out of the 7 applications, only 4 applications have been passed and balance have been withdrawn. What are the reasons that PPRP is not successful? First and foremost, I told you that some of the amendments what they are proposing, if that amendments are accepted, that can give in little more comfort level for the MSME series to go for PPIRP. Certain other amendments what should be looked into is, in case of a PPIRP, you have to approve the base resolution plan. The banks or financial institution will not be capable of taking a decision within 2 weeks. So the Banks Association, Reserve Bank of India have to come up with some kind of guidelines. What should be the process adopted by the bank when they are going to give the approval for the base resolution plan? Because the timelines is very important. The banks are taking a lot of time to approve the base resolution plan or to approve the alternate resolution plan. If they come up with some kind of uniform circular by the Reserve Bank of India or the Association of the Banks, I am sure it is going to be a proactive approach for the success of the PPIRP. The second thing is, most of the MSMEs are not aware there is something which called as the PPIRP, special benefits entitled for MSMEs under the IBC laws. So government has to take little more initiatives, and the industries and commerce have to take more initiatives to educate the MSMEs, telling them about the benefits of PPIRP for the financially stressed MSMEs. And also another important aspect is with respect to the level playing field. In case of PPIRP, it says very clearly you have to make provision for the 100% of the outstanding operational creditors. Whereas in case of a financial creditors, they are taking a haircut to the extent of 80-90%, but operational creditors, you cannot make a haircut to operational creditors. If you try to not pay 100% to the operational creditors, the base resolution plan itself will be non-compliant. So they have to come to a level playing field. There has to be an amendment to the law where the operational creditors have to be in par with the financial creditors. Last but not the least, whatever the proposed amendments are there, in case if these proposed amendments are considered, I am sure that there will be many more success stories with respect to the PPIRP. In the conclusion, what I can say is with respect to the advantages as far as the PPIRP is concerned, this is, as of today, benefit is available only for the MSMEs. During the course of the process, you are entitled for a moratorium. You are financially stressed. When you are financially stressed, there cannot be any cases against you. There will not be any further recovery proceedings against you. Even the essential services like power or water cannot be disconnected even if you have defaulted the payment. So there is a kind of comfort level during the course of the moratorium. And PPRP is the only process under the IBC law where you have an opportunity of a first revival process, where you can informally discuss with the creditors to come to a settlement, come up with a base resolution plan. And if you see the entire process, it's in the most transparent manner to maximize the value for all the stakeholders. And creating this awareness is the last, as I told you, that they need to create more awareness to make this PPRP to be more successful. I have not shared my slide along with the article what I have given. If any one of you are interested in the PPRP, you can mail it to me. I can send you the slides what I have prepared. I put in lot of efforts in putting the entire process in place. Even though I am hardcore insolvency professional as of today, it has taken a lot of time for me to put all these things together as a package. If any one of you is interested, I can definitely mail it to you. You can make a note of my email ID. I can share all these slides. So these are my concluding remarks. With this, I once again thank the Southern India Legal Council for giving me an opportunity to be present here and share my thoughts on the subject of overview on benefits for MSMEs under the Insolvency and Bankruptcy Code. Thank you very much for a very patient hearing.